gentlemen, TGIF, it's Friday already. Looking forward to the beautiful weekend. Today, you're really coming for a treat today. And we have a very prolific speaker, Nancy Chan, very knowledgeable from a lawyer's title. She's going to talk about how to take titles in the real estate. As you know, there are many ways to take title. Then she has a very profound language on this area. So without further ado, Nancy, take it away.
Thank you, Peter. Thank you, Edgar, for putting this on. And this is going to be a very casual class. If you want to ask questions, put in the chat room and you can raise your hand and we can unmute you to talk. So everybody's muted right now, but that doesn't mean you can't, ask questions. Well, like Peter and I were talking about, I've been in the business 40 years. This is my 41st year. April was my anniversary for 40 years. And the reason I stay in this business is because I really enjoy meeting everybody. And sometimes I meet the agents, buyers or sellers also, if they really have questions. And I'm happy to meet with them to explain some of the things that's harder for the agent to explain. For example, what I'm doing now. And sometimes it's not good for you to ask certain questions because they don't tell you. But if they want me to help, I can ask the tough questions. And that's one of my thing about helping real estate realtors and helping you close your transaction. One of the most important thing that I see for a buyer's agent, and when you're a buyer's agent, your buyer is giving a form, buy escrow, how to take title. And I've looked at the form a few times. It's a little confusing. But so I'm here to give you a little background of why ownership and how to take ownership makes a difference in the legal ramification, also tax ramification. But I'm not a CPA, I'm not an attorney. So what I'm going to give you today, I'm going to talk about just common ways of doing it. But everybody's situation is different. If your buyer have tax questions or legal questions, they should, we all know we should refer them to the professionals, because I'm not a CPA, you're not a CPA, I'm not an attorney, you're not an attorney. So this is the one thing that I tell all my realtors. It's a disclosure you have to tell your client. Okay, so without further ado, I'm going to introduce myself, Nancy Chan, lawyer's title. I'm not leaving. I grew up with this company. I have friends in this company for 40 years, and relationships, like and I know, are very important to our business because we deal with people. So the best service we can give our client, help us get more business. So I will send you ways of taking title, and I will give it to Peter and Edgar. He can blast it out to you later. I don't have any screen sharing because screen sharing, you can't read it anyway. It's too small. Secondly, you're trying to read it and you're not going to listen to what I'm going to say. Okay, so very simple. I'm going to talk and you can ask questions. So I want to clarify a couple things. A lot of people say, he's a single man, she's a single woman. Let me clarify what single means in the eyes of the law. Single means never been married. So if a woman is divorced, in her social circle, socially, she's single and available, maybe, maybe both. But in legally, she's not single anymore. She can never be single. She's an unmarried woman. Okay, so I have a lot of agents ask me, well, she's single. I said, no, she's divorced. So she's an unmarried woman. Same with the man. Socially, if you're divorced, you're living by yourself, or you're widow, you're single. But let's talk about when the husband or the wife passed away. They're still not single. They're widow or widower. Number one, okay? Because I have buyers argue with my agents, and my realtor said, Nancy, she wants to put a single. I said, no, she's divorced. She's single means the person that's never been married. Number one, okay? Agents, remember that, because I get people calling me all the time. She wants to put single woman and then with her son. I said, what do you mean single woman with her son? Well, she's divorced. I said, no, unmarried woman and a single man. That's her son. But she cannot say she's single. Okay, number one thing. Most of my foreign buyers gets very upset when you tell them you can't put single. You're unmarried woman or a married man. Unmarried. That's their status now. Okay, so that's one thing out of the way. There is also tenants in common. Tenants in common now means if there's two people, they can do tenants in common. There's three parties, they can also have three people on title. So tenants in common, any number of people, single or divorced or married, whatever, you can have 10, you can have 11. And that's tenants in common. Also, if you have two people, you can also specify their share, their percentage in this property. So maybe I bought a property with Peter and we're doing investment and Peter has more money. So Peter put more money down and then I put less money down. He can be a tenants in common with me and he will be 80% and Nancy Chan has 20%. We're tenants in common. Or there's 5 of us. So each one can have different share, okay? And you gotta make sure when you have more than 2 people as tenants in common, you better specify percentage. That's different than joint tenant. I'm talking about tenants in common right now. Tenants in common, please specify percentage. Because we don't know Peter put more money down 5 years down the line, and I'm gonna argue with Peter, say, we're 50-50. Peter says, no, I put more money down, I'm 80 and you're 20, then we're gonna go into a courtroom. Because title company said, we don't know, you guys didn't put the percentage down. Does that make sense? Okay, if you have any questions, there's the reaction in the bottom, you can raise your hand and we'll put it in the chat room, okay? So tenants in common could have any number of and specify percentage. Maybe there's 3 people, Peter have 80, I only have 5, and then the Kathy has 15, right? So tenants in common has any number of people, you have to specify percentage, okay? And tenants in common also, tenants in common has legal ramification too. The advantage of having tenants in common, if you ever go to lawsuit, let's say Nancy Chan gets sued and somebody wants me to sell my property or lien, that they can only lien my percentage, my 20%, and Peter is not going to be affected. He might be affected trying to get me out or buy the creditor out, that's my creditor, but they can't lien his portion. Okay, in reality, still he's going to have complication. He has to deal with the creditor, but they can't take his 80%. That's tenants in common because it's separate title. That's why you need to have percentage specified. Okay, and tenants in common also, husband wife can be tenants in common. You say, oh, Nancy, I've never heard of that. Husband wife never takes title as tenants in common. They usually do joint tenancy, community property right of survivorship. Why do they do that? They kind of want their estate separate, maybe. But when they're married, even though you take tenants in common, you still have other advice that they need to go talk to their CPA or their attorney. But tenants in common, husband and wife can take title as tenants in common, but the other things you and I should not get involved, okay? Because they still are under community property law because they're married. That's California. Anybody doesn't know that California, husband, wife, always community property law? Okay, so that's tenants in common. Most people don't know that husband, wife can take title as tenants in common, but it gets complicated with legally and financially, all right? So I've done 3 things so far. Single woman, single man, that means they've never been married. If they are divorced, they cannot say they're single. They can put it on Facebook, or Match.com, they're single. But legally, they are unmarried woman, unmarried man. Because I know some people just came in late. So I want to specify that. I said that already. Second thing, okay, if your husband or wife passed away, you still are not single. Socially, you're single, but you're a widow or widower. Okay, that's important. Okay, so I have a lot of clients that come from overseas. They insist on being single. They're not. Okay, if they've ever been married, they can never say they're single again. I don't care if they divorced 3 times. They're still unmarried person. Okay, so the second thing we talk about is joint tenancy. Listen carefully. Joint tenancy is different from tenants in common. You can also have multiple people as joint tenancy, but you don't have to specify percentage of share. They all has to be equal share if they take title under joint tenancy. So if there's 3 people, it's 1/3, 1/3, 1/3. 4 people, 25%, 25%, 25%, 25%. 10 people, 10% each. That's joint tenancy. The reason is joint tenancy has survivorship. Survivorship means if Kathy and I took title together and I die, I'm older, so I passed away, and we took title, Kathy Wong and Nancy Chan, single women or whatever, and then joint tenancy. If I die, Kathy gets my 50%. The survivorship makes the difference. That's why you have to have equal share, because if it's not equal share, why should I give Kathy more? And when Kathy dies, let's say I have 60%, she has 40%. When I die, I give her 60, she dies, she only give me 40. That doesn't make sense. So joint tenancy, because of survivorship, everybody's percentage is equal. You don't have to specify it. Joint tenancy, once you put joint tenancy under the 4 people's, after the 4 people's name, automatically it's equal share. Anybody doesn't understand that, please raise your hand, I can repeat. So joint tenancy can have 2 people or multiple, any number of persons. But the share, if it says joint tenants, everybody's share is equal. It cannot be different because it has survivorship. So how do you transfer? I'm doing a couple of them right now that the joint tenancy, somebody passed away. So how do you take the other person off title? You have to provide a certified copy of the death certificate, a death certificate. It cannot be a copy. The county they don't record anything that's a copy. It's a court certified copy of the death certificate, and that's usually when somebody dies, the funeral home will order it for you. So my suggestion is to interrupt this thing about death certificate. A lot of your client will call you, say, my husband passed away, or whatever, whoever passed away, the property you bought for us. This is time you tell them, when you go to the funeral home, don't just ask for 1 copy of the death certificate. You need more. When my dad passed away, I ordered 12 because there's 5 of us, 5 brothers and sisters. I gave everybody 2 copies plus 2 to my mom. Because they're harder to get now. You have to go to the county recorders. You have to fill in the form. You have to get it, and it costs money and it costs time. Even before you can walk into the county, pay them, they still take a couple of days for them to mail it to you. Okay, so if you have somebody that passed away, your client tells you, tell them to get multiple copies of death certificate, because they have to use for their property, for their bank account, for their 401k. Sometimes if the father passed away, I have to do that for my father's social security, go to my mom. Okay, so all of those require a certified copy of the death certificate. Okay, let's go back to real estate. How do you take a dead person off of title when it's joint tenant or tenants in common? You filled out a form called affidavit death of a joint tenant. And it has to get signed by somebody. It could be signed by anybody, not the relative. You don't have to be the wife or the relative. And you provide that notarized copy of the affidavit, death of a joint tenant, plus with the death certificate to prove that person is dead. Then we can record it for you. Once that records, that person's name is off title, even though the grantee still have his name. When the title company search the property profile, it will show that certificate and the affidavit of death of a joint tenant in it. So we'll know that person has passed away. Am I making myself clear? Or if I'm not clear, you're welcome to ask, okay? I think I'm pretty good about delivering my message, and most people can understand, but sometimes I speak too fast. Okay, tenants in common, the same thing. You will have affidavit of death, but tenants in common could be a little tricky. If somebody passed away, guess what? It goes to what? Probate. So there's a flaw in tenants in common, because that's individually held by that person, the percentage. So how do you get rid of that person? Well, talk to your attorney. Talk to your real estate attorney or probate attorney, okay? So tenants in common can be tricky when somebody passes away, because the other people on title cannot touch his or her share. So if you're taking title with somebody, like going back to Peter and I, Peter has 80%, I have 20%. So Peter doesn't want the property to go to probate. Guess what, Peter? You should transfer that 80% into your trust. And I should transfer my 20% into my family trust. Then it doesn't have to go to probate. And the trust will tell who is a person that inherits this property, that has the right to this property. Okay, it gets a little complicated. I don't expect you to understand everything. A year down the line, something happens and sometimes you forget. Give me a call, okay? I will tell you what to do. So joint tenancy has to have equal share, any number of people. It doesn't go through probate, because the survivor people, the person that survives, gets it. Okay. If the tax issue, don't talk to me. Capital gain, inheritance tax, all that, go to the CPA. Okay. This is exactly what I'm saying to you now, is exactly what you should say to your client when they have these kind of questions. What about my capital gain? What about estate tax? Yes, you will have to tell them you can't really explain that. They should go talk to their CPA. And this is what I tell my agents and the buyers and sellers too when something happens. I tell them, I have to go to my CPA, so I don't know everything. And you have to talk to your CPA as a realtor with your tax issue, so you talk to them and then have them talk to their CPA or attorney, okay? So joint tenancy, right of survivorship, any number of person, also absolutely equal share. 3 people, 1/3, 1/3, 1/3, 10 people, 1/10, 10% each. Okay. The difference with tenants in common and joint tenancy is joint tenancy have right of survivorship. Tenants in common, you don't have right of survivorship. You can have different percentage of share, and your interest is held independently. Joint tenancy, if there is a lawsuit, somebody gets sued, everybody is liable. That property is liable. Okay. So why do you think we tell people all the time to go to put a trust, get your share, get all your property, whatever you own, into a trust? It's there for your protection. That's why I had an attorney came on last Wednesday and this past Wednesday to talk about trust. So, all right, any questions so far? Put it in the chat room. Anybody? Okay. Carlos, mute yourself, please. All right. Another thing I want to talk about is now we're talking about husband and wife. Remember, husband and wife in California is considered community property. As soon as you get married, it's community property. I have a lot of clients talk to me about, oh, this property was purchased before marriage. Okay, you are a realtor. I'm a title person. We don't get involved with their community property situation. We can't tell them, yes, that's before marriage, so your wife cannot have it or your husband have no right to it. No. Okay, because they're husband and wife. In California, it's community property law. It's really difficult for somebody to go to court when they go through a divorce to declare this is before marriage and you can't claim, because that doesn't work very well. Okay, so we don't get involved with property prior to marriage. They need to talk to their attorney. Okay. Once you get married, from the title company's point of view, very simple. If Nancy Chan is married, everything I bought previously, even though I was a single woman, now I'm married, my husband has right to it. Okay, unless we go to the attorney, do a prenuptial, do everything. But people say, oh, there's a prenuptial. If it goes to a title, go to escrow, let's say I'm selling one of my property and I bought it before I got married. It was under a single woman, but I'm a married woman. He does have to sign a quitclaim. My husband has to sign. From the title company point of view, why? Very simple. All your title rep will agree with me. Title company is to eliminate risk. Our job is to make sure the buyer buys the property has no risk. We're eliminating all the risk. So what if my husband did not sign the quitclaim when I sell? Later on, we have a big fight about whatever. He files for divorce. He can come and claim this property because he never signed a quitclaim. And the title company or my realtor, which is Kathy, don't want to get involved with that. You're going to get sued. Title's going to get sued. And the buyer is going to be very upset. So that's why we're preventing a lawsuit. And in a way, a lot of realtors say, and the buyer for going to court later. My husband and I may be wonderful right now, but who knows? Okay, the status of the person at the time of sale is important. So let's go back to joint tenancy. Go back to tenants in common or joint tenancy. They all took title prior to marriage as a single man, single woman. Now one of them, or who, they all want to sell. If all three people, they're tenants in common, they're married now, all the spouses has to sign. Because we don't want to have any loopholes that somebody can have a problem later to sue. Let me give you a scenario. Assume my husband's doing really well now when we sold the property. Everything's fine. He got divorced. He had another girlfriend. His business lost.
Okay, I just bought the red one, but I want to buy the yellow one. Okay.
Okay. How can I mute everybody? Let me do.
Just get this one. Okay. Yeah. Okay. Thank you.
Zoom user, can you mute yourself? Somebody, Julia, mute yourself, somebody else. Okay, so let's say 5 years later, he's not doing well. He's desperate.
Got the ice cream.
How do I do that? Okay, I'm gonna. Okay, so.
Can I leave my card here? I forgot something.
Let me see what I can do. Because I can't see her name. Let's see, who is that Zoom user? I'm gonna see if I
Erica,
can find it.
Erica, can you
Okay,
mute the Zoom
I'm,
user,
I'm,
please?
yeah, I don't know how to
Yeah,
mute
I
this.
don't know how to mute her either. So she was talking. Erica, can you help?
No, I'm trying to let Edgar have. What is that person? Zoom user. I can't find him. Hold on, give me a minute. I can probably find him. If I can find her, I can mute her. That's why sometimes when I do my classes, I want people to put their name in. So I can tell who is it.
Can I pay for this real quick?
Somebody's talking. Please mute yourself. Okay, I think I found it.
Found it? Okay, yeah, you got it. You got it.
Okay, I got it. Okay,
thank you.
good. Okay. Yeah, I have to go through the people attending. So when people are desperate, they can always find a way to sue. And Peter and I know, because we see lawsuits not because they're right or wrong. Lawsuit is a strategy to get a settlement. They sue you so you can get some money. They can get some money. So, but why do you as a realtor or me as a title rep, we want to go into lawsuit 5-10 years later? And you know what? Now, if you see any lawsuit, because I read lawsuits all the time, when they sue, they always put fraud, because fraud, the fraud is the statute of limitation begins upon discovery. So let's say 10 years later, they think they found out, or they claim that you didn't tell them when you were selling and they didn't sign a quitclaim deed. They discover 10 years later, they can still sue you because the clock begins upon they discover the fraud. And that's why I didn't see lawsuits like that with fraud years and years ago, but in the last 10-15 years, every lawsuit, they always say fraud, because that's a loophole. Attorney can use that to go back and claim for previous discrepancies and little mistakes, okay? So as soon as somebody gets married, title company would consider everything that person owned prior, during, whatever marriage, especially the prior marriage, we assume is community property. California law. Community property is California law. Okay, so that's something that I think I have a realtor ask me yesterday, she's signing a listing, two sisters bought a property as a joint tenant. Since then they both are married, and said they both have to sign quitclaim deed. Take the listing now with the sister's name and let me be the bad person. When I do the prelim, I will tell them they need to sign quitclaim. If you don't want to get involved to do that, let me get involved. I'll be the messenger that brings them the bad news. Okay, that's a title company requirement. Okay, you're a realtor. You don't do title requirements, right? So be the good person. I'll be the bad person. All right. So now joint tenancy, we're okay, right? Nobody has questions on joint tenancy anymore. Equal share, any number of person, and then husband and wife as joint tenancy. So let me go to husband and wife as joint tenancy. That means if one spouse passed away, the other one, they do an affidavit, death of a joint tenant, give title company a certified copy of the death certificate, we record it, and whoever that passed away, the spouse that passed away is off title. But because there's a tax issues, when somebody dies, they have inheritance tax, they have estate tax, property tax, all that stuff. Property tax won't get reassessed because husband and wife are considered one party in the state of California. Okay, so the wife is still on there. Property tax will not get reassessed, but you're going to have estate tax, whatever those. You need to do an appraisal within 12 months of the death, within the same year. That's a preference. Okay, so So because later on when the wife sells, are they going to have a step-up base? Are they going to pay for capital gain? The CPA will want appraisal. So I have one right now that I'm trying to find somebody that appraisal can do one for the wife that the husband passed away 3 years ago. So one of my appraisal friends on vacation, so I can't ask him, but it becomes challengeable by the IRS. So hopefully once they do it, IRS will look at it because the wife is selling the property to move to another county with the kids. So if you do have long-term clients, and if your client saying that my husband or wife is, I'm not doing well, or they pass away, your advice to them is hire appraisal, do appraisal then, and keep it there. Okay, because they will need it when they sell the property. Okay. So joint tenancy for the husband and wife is pretty simple. Community property, we still have community property. Husband and wife can take title as community property. Remember what I said about joint tenancy between husband and wife or anybody? If there is a lawsuit, there is a creditor, the whole property, when you have joint tenancy, is going to be under the claim, okay? So, but community property, when it's only husband and wife, okay, husband and wife can take title 4 different ways. Tenants in common, joint tenancy, community property, and community property with the right of survivorship. Community property, if the husband and wife take title as community property without survivorship, sometimes legally, if there is a lawsuit or a claim, they can separate the community property, but also talk to your attorney. There are some people that used to only take title under community property because they don't want the husband or the wife to get it. They don't want the survivorship in there. Second marriage, parents, family situation. That is something that you don't give them advice on. If they say, I don't want my husband to get my share, even though I'm married, I'll say community property, talk to their CPA, talk to their attorney. We don't get involved with telling them what is the best way to hold. I get questions a lot. Nancy, what is the best way to hold title? I said, well, I don't know your clients. So give me some more information. But when it comes to, I don't want him to claim, I don't want her to claim, then I'll say they better go talk to their attorney. Okay? Make sense? Community property, it was very popular years ago because they have a capital gain step-up base. So if the husband passed away, okay, in 2022, his 50%, if the wife sold it in the year of 2022, the same year he died, his 50% usually will have a step-up base that there's no capital gain. She will only pay her share from 1980 to 2022. That capital gain. If she sells it instead of 2022, right out the same year he dies, if she sells it 2025, his 50%, the step up will be from 2022 to 2025, only 3 years of gain. But like I said, talk to the CPA. I'm just giving you an example. Okay, so that's why a lot of rich people in Beverly Hills used to take title husband and wife as community property only because of prior marriage. They don't want the husband to get share or the wife. They have this capital gain step up base. But in 1990 something or before 2000, the community property with the rights of survivorship came in. Because community property has no right of survivorship. If the husband writes a will say mine goes to my ex-wife, don't you think there's going to be a problem? Because in community property, without survivorship, you can give it to somebody else. You can have a will. So the Bar Association of Beverly Hills, Peter, this is interesting. Beverly Hills property goes up a lot, and the prices are high. A house worth $2 million in Arcadia might be worth $4 or $5 million in Beverly Hills or Brentwood. So the Bar Association of Beverly Hills initiated this change. So they added the community property with the right of survivorship. So you can have the capital gain step-up base. Also, you have the survivorship. So the most popular one right now for husband and wife is community property with the right of survivorship. Any tax issues, your client asks me, which one is better? You don't know them. You don't know if the husband has a prior marriage with another kid, right? So don't give them advice on any of this. I want you to understand it. You can explain it to them, but you don't tell them which one is better for them. Okay? Okay, let's see. There's a couple of chats in there. Okay, appraisal. Somebody asked me a question on appraisal. When somebody dies, one of the joint tenant or husband, wife, somebody dies and you're not selling the property, there's estate tax. Okay, so that tax will be based on when they die to when you sell the gain. So when you do appraisal, when you file taxes 10 years later, you have appraisal to give it to the CPA so the CPA can do the taxes for you. And if you don't, I have a CPA costs me all the time. Nancy, they don't have appraisal. Can you give me comps for 1999? I can find comps. I can give you comps all day long. I can find comps in 1970, but is the IRS going to accept my comps? IRS is, nobody controls them. I can't control them. I can give you comps from 1990, 1989. I have somebody that's in 1985. I gave them some comps. But if the IRS is going to accept that, it's different. So the appraisal that's done at the time of death will not be challenged by the IRS because they say, oh, you got a formal appraisal. It was done the same year when your husband died or your wife died. Did I answer that question? It's for future tax purpose. Okay. Anybody have any questions? You know what? Peter, can I allow them to unmute themselves? So we have another 15 minutes for questions.
Yeah, you can, of course, you can have them unmute themselves. When they want to talk, they can always unmute themselves.
Yeah, can you
can do
unmute
that
yourself
on
if you have any
their
questions?
computer. What's
Okay.
that?
What?
Whoever wants to talk, they can unmute themselves and talk.
Yeah.
So
So,
any question from anybody?
Yes.
Hi, Sylvia.
Hi. Okay. My question to you. Okay. If we had, we just recently got a family trust, and the way we had it before, I guess, I don't know whether it was joint tenancy or tenancy in common, one or the other. But now, since we have the family trust and we got that recorded, that supersedes whatever title we had, correct?
Yes.
Okay,
Also, Sylvia,
Mhm.
I've run into situations, realtor call me, says somebody died and and then I said, okay, they both passed away, husband, wife passed away. They said they have a trust. When I look on the title, they did not transfer their property into a trust.
Oh,
That
wow.
happens a lot.
Yeah.
Peter, you and I know this really rich guy that used to own a lot of real estate in Monterey Park, Alhambra, Rosemead. Stu May knows him too.
Yeah.
He is the first person that used to drive a Rolls Royce in Monterey Park. He has so many properties, but he put everything, he granted all his property into a trust, but there was no trust.
Oh my gosh.
You know, the estate, his brother and sisters and ex-wife, they fought the estate for 15 years.
Yeesh.
Okay.
Well, very unfortunate. Well, they,
Yeah.
Very
they should
unfortunate
know
and
that.
very
He
expensive, I'm
was
sure.
he was very wealthy, but he went to a seminar about trust And he did it, but he was too cheap to go to an attorney to set up a trust. Vice versa. If you set up a trust, I'm listening to this right now, okay? This just happened last week. One of my realtor called me and said, my client did a trust, but his attorney didn't want to do the transfer of the property to the trust. He wants them to do it. Otherwise, he's going to charge him extra $500. I'm like, what kind of attorney is that? If the attorney is doing a trust for you guys, he knows all the property you own. He should grant it into the trust for you. Right, Peter? That's the right way to do it.
But I'm telling you, now a lot of the attorney out there, they would just hire the paralegal to do the paperwork of the trust. They'll never fund the trust. So you have to be very careful. If you don't fund the trust, there's no use.
Okay, to answer Sylvia's question, if you set up a trust and the property is granted into a trust, it supersedes everything else. Remember
we got the recorded deed already showing the trust.
That's
right.
good.
I have another question that was very strange.
It took a while, but we got it.
Yeah, but so Sylvia, you know, if one of the spouse die, you have to appraise the property. You have to do do a little bit of a trust administration in order to get everything right. Okay.
Right. Yeah.
So you cannot
Okay,
just,
and I was
No,
talking
we did
to,
that. We did that in right about Thanksgiving, and we finally just got the paper because we waited and waited and we asked. We finally got it. It got back to the attorney for some reason, and then the attorney went and sent it again and had them forward the recorded copy to us. So we got that copy already.
Okay, I will do a special favor for you guys. If your attorney does the trust and does the grantee for you into the trust, give it to me. I can record it faster. And when I record, it takes a week for me to record it. And as soon as I record it, I will give you a stamped copy.
That's nice.
Yeah, because a lot of my clients, their clients are older and they grant it into trust. They don't get the deed. They get all nervous. They can't sleep for a month. Okay.
Yeah.
So we have an accommodation desk that I've helped Peter record some stuff. And if I take it today, you'll probably get recorded next Wednesday or Thursday, and then you get a copy emailed to you. The original will come in the mail.
yeah, that Nancy did one for me. It's very quick. So
Yeah. I don't want your client. Steve, you provide service to your sellers and buyer, your old client. And when they ask you to help them to do something, they expect really good service. I want you to at least give them that service so they will like you more. So they will give you more referrals in the future. If you let them wait 2 months, they're not going to give you a referral. They might say, Sylvia forgot about me. Nancy forgot about me. You know, Young Chen forgot about me. Don't delay on these things for your clients, because service is really important. Another thing I want to mention, Peter and I, we've been in the business a long time. Years ago, if you look at the property profile, you see a trust. They'll just say so-and-so grant it to a name of the trust, dated, whatever. But now county recorders are getting very picky. I think they've had some legal issues that have to go to court to resolve for other people. They don't want you to say Nancy Chan grants it to Nancy Chan's trust anymore. They want to say Nancy Chan grants to Nancy Chan, trustee of the Nancy Chan Trust, dated April 9th, 2022. They want the trustee name to be on there because they want to make sure whoever signs the deed later, if they sell, it's the same person, because they don't have a copy of the trust.
that's right.
And they're relying.
And also the trust is not an entity to own the property. Okay, it's your person, the trustee who owns the property.
Yeah. So before, I've seen a lot of old documents that they don't have the trustee name on it. For the last 10, 15 years, the county requires the trustee to be on the deed. So Sylvia, look at your deed and see if that's on there. So a lot of the trust has 2 or 3 trustees. So they want all the trustees' name to be on there. So they can make sure these are the person that really owns the property. They can sign paper. They might sign paper to deed it out, Peter, 3 years later. But if the county looks at deed and it's not the 3 trustees, they're going to have a problem. So they want to see who's the trustee now. So be a little careful. And I mean, Peter and I, we know a lot of people. I do have several good trust attorneys. I have 2 that speaks Mandarin and 1 that speaks Cantonese and Mandarin. And I have English speaking, just basically good trust attorney. They do a good job for you. Don't go on the website and try to download a trust and do it yourself, please. That's the last thing you want to do. If Peter's not doing that, Nancy's not doing that, that means you're not supposed to do that. And I think we're better at paperwork than you. So don't go and download something and put it in the trust. Also, trust has a lot of good things that, not just for real estate, your 401k, your bank account, your life insurance, all that could be there. Your antique jewelry, your whatever collection you have. I have elderly. She has a great collection of English china that's worth a lot of money. And that was in the trust. So the kids are not fighting over it. Because I see a lot of things that besides real estate, that's in the trust, which is very good. Okay. All right. I have a couple more questions. Let me see what it is. Oh, the step-up base. Okay. Mary Scott, the step-up base means when you bought the property in 1980, we have a lot of that. I saw something that was purchased in 1979. That's I'm doing the title on. So when somebody dies in 2020, that person, if it's community property, gets a step-up base or community property right of survivorship. So if the wife sells the property now, the capital gain of the dead person is not going to go from 1980 to 2020. That's a lot of years. That's 40 years of gain. So the dead person's gain is stepped up to the day he died to the day he sells. So the 50% of the husband that died, his capital gain is going to be based on the time he died. That's a stepped up till the time he sells. So if it's sold at the same year, he might not even have to pay gain on the 50% of that third person. That's called the step-up base. The trusts have the step-up base too, so don't worry about that. That's why I always say, do the trust, because you will automatically have the step-up base.
Nancy, excuse me, what I meant was, is there only a 50% step up?
That person died.
Yeah.
Okay, that person that's dead, but the wife is not dead. So the wife sells it. The wife does not have the step-up base because she's still alive. She pays capital gain on her 50% from the time he bought it, 1980 to the 2020. But the husband's is stepped up. So
Yeah,
the
but
50%
when this wife finally died, the wife also have that step up.
step up, right?
I know that.
After
I know that when they're both dead, they get 100% step up.
Right,
But-
that's
Right.
But if the wife sells it after the husband, the spouse dies,
Yeah, only
he
50%.
does the dead person gets 100% of the step up or 50% of the step up?
Yeah, his
50%.
portion gets stepped up, his portion.
So it's 50%.
Yeah, his portion, you're right.
Thank you.
You're welcome. Thank you for clarifying that, so everybody
Yes.
understood. Okay, so,
Can you hear me?
yeah, Oscar.
Yes, I have a question, Nancy. You were saying about doing an appraisal when somebody dies. So if somebody dies, say the husband dies, the wife has to do the appraisal whether
year.
she wants to sell or not? Just to
No,
be on the safe
if
side?
she sell, okay, Oscar, very good. The appraiser is to establish the value of the property at the time of death. Because she can sell it now, then you don't need an appraisal. But if she doesn't sell it for 5 years, they want to know the value of the property when he dies in order to calculate the step up based on the tax. Does that make sense?
So he dies in 2000 and they sell the house in 2005, they have to do a step up in 2005 from 2000 to
No. Okay. Okay, let's say the husband dies this year. Okay. The wife is not selling. She should do appraisal now for 2022, right? She sells 10 years later. She used the appraisal 2022 to establish the step-up base. So she only pays from 2022 to 10 years later, 2032, the tax she will pay. Because otherwise the IRS is, well, we don't, how do you come to this? You don't have to pay the taxes for, since from 2022, how do you have that value? So you do the appraisal now when the person dies.
Okay, so yeah, that's what I meant. So it's a good idea to get it done regardless you're
Yeah.
planning on selling or not, just to
Yeah.
be on the safe side.
Yeah, when somebody dies, do appraisal because you don't know when the wife or the husband is going to sell later, but you have to establish the value at the time of death.
Okay, great. Thank you very much.
Because the IRS might challenge you. IRS, then you get a comps, and the comps is not a formal appraisal. Okay.
Great. Thank you, Nancy.
Okay. So now you
Question for
can.
you, Nancy.
Yes. Yes.
Okay, I got my grant deed in my hand, and the portion of it where it says the sign is correctly spelled with the I, because you know my name is with Sylvia with an I instead of the
Yes.
traditional Y.
Right.
But on the body of it, it shows it with a Y. Does it make a
Uh-oh.
difference?
Yeah, it does. Scan and send it to me or take a picture and you might have to re-record it.
Oh, geez.
If
Okay,
the name is wrong, we got a problem. See,
okay,
be
Yeah.
careful. Okay.
Yes,
One more thing. One more thing for all of the buyer's agent. Number one, very important, because I get this every month. Every month I get a problem that I cannot solve. Okay. You know, when you filled out the form, buyer's information, you filled out their name, how they want to take title, very clearly. I know you filled it out. I've seen you fill it out. Then who types up the grantee?
Escrow.
Escrow does. But you send in the form, right? So escrow's supposed to follow the form, right? But escrows are very busy. I really feel bad for the escrow right now. They have to deal with lender, home warranty, insurance, all that stuff. Please, you filled it out right. Every month I get somebody to call me, Nancy. The grantee came to my buyer. The name is typed wrong like Sylvia's, but that's only a minor mistake. But I have one that happened to one of my old realtor. The mother and the son was buying the property as a married woman and a single man. The grantee came back, husband and wife. I didn't know what to say. My agent says, they're Chinese, they're from China, they're pissed. That did all the stuff for them. You're the one that helped them, right? You're the first go-to person. And of course you make money. So they always blame whoever that makes money. What happened is they did fill out the form right, but whoever did the deed, it could be they transposed it or whatever they did. So you know how hard it was to have it re-recorded and changed? Because once it's recorded, it never disappears. You have to re-record a correction deed. Peter, this is very important for the agent to know. Years ago, this mother and the son can deed it to themselves and correct it. The county does not allow that anymore. They want the original seller to redo the deed. Guess what? The seller is in Tennessee. And they're very old. It took me 6 months to get this thing done. And I wasn't even on the title because the buyer couldn't get me title on it. Okay?
Yeah, that makes sense.
So number one, I don't care how good your escrow is. We're all human. If I make mistakes, Peter makes mistakes, everybody can make mistakes. Give your buyer's agent, please ask your escrow officer to email you a copy of the grantee before the seller signs it. You make sure your buyer's name are correct, the vesting is correct, everything is correct. Then you okay it, and then escrow can have the seller sign. I have escrow company, they're gonna fight you. They will fight you, say, why do you need it? You don't need it. No, this is what you tell them. when it's recorded, that deed belongs to my buyer. And by the way, honey, I really like your service, but I think my buyer pays for your escrow service too.
Nancy, I hate to interrupt, but I have to hop on to another meeting. So
Okay,
I'll
go.
see you guys later, okay?
Yeah,
All
thank
right,
you.
have
But
a nice weekend. Have a nice
thank you,
weekend.
Peter.
Thank
So,
you.
so buyer's
Thank
agent,
you, Peter.
be very careful. You need to review the grand deed because if it's not done correctly, like Sylvia's name is spelled wrong, that's not even, that's a small part of spelling wrong is not. If the vesting is wrong, the percentage is wrong, you got a problem later. You try to correct it. And you have to try to find a seller to redo it. County is very picky now. Okay, and they want the original. If you have the original, it's fine. If you don't have the original, you have to redo a deed from the seller to you again. So this is my tip for the week. And I see there's another question in the chat room. Good question. Yes, Mary Scott. Yes, you can take title as a trust, but if you're getting a loan, lenders do not loan to trust. Most of lenders don't. I know a few does, and Morgan Stanley, if they do your loan, or Merrill Lynch. I have people that buys only with Merrill Lynch money, and they will allow you to take title as a trust. But most conventional bank and mortgage company do not allow you to borrow money using a trust. Okay, even when people refi, another tip. Let's say you own a trust, Mary Scott, or Kathy, or Young. You own a trust, you want to refi. The bank wants you to take it out of the trust so you can take a loan. But a lot of banks forget to tell you to put it back in the trust.
Yeah, that's true.
So yeah, you've seen that happen, right, Mary?
Yes.
So be careful when you come to do, let's say your client says, I'm doing refi, and you know they have a trust. You better remind them, because you know why? Even though the bank screwed up, they're going to come to you, Mary, and say, help me, help me. And if the person dies, it's not under the trust. I have one right now that they did a trust. They took it out of the trust to do a refi. 10 years later, the husband dies. Now, no, sorry, it wasn't, they both died. Now they go to what? Probate.
Yeah.
Okay, so be careful. I'm giving you a lot of kind of bad news, but I want you to be prepared for these things. So whatever I say, I hope that you listen. I hope you enjoy my class. And if you want to call me anytime, my number is on the screen, and all your assistants have my card, my numbers. Give me a call, and I hope that I can help you with your future business. Even if it's not my deal, if you need something, give me a call. I can give.
Nancy.
Thank you.
Thank you, Sylvia. Christine, thank you, Mary Scott, for your input. And Ming for joining, Cecilia for joining, everybody that Lena, everybody, Joseph, Diana, thank you so much. All right, I'm gonna leave now. Have a good weekend.
Bye-bye. Thank you again.
Bye.
Bye.